Today we are moving on to the freedom of speech 5.3. So get them pencils ready and let's go ahead and get through it. The majority of this unit is going to be covering our major court cases, but there are a few tests that were created by the Supreme Court that you are going to need to be familiar with as well. So let's go ahead and dive into it. All right. This is one of our major court cases. Once again, do them on Classroom. Let's go. Okay, this is one of your five. Shank versus the United States. This is going to be the first time in U.S. history where the Supreme Court is going to examine a free speech claim. It's going to be during World War I, or I guess right after World War I, considering activities that were done during the time of war. And it's going to be about ignoring the draft. And what you need to know is this, is that the Supreme Court came down and said that the government can limit speech that causes what they called clear and present danger, because what Shank was doing, he was a member of the Socialist Party, is that he was sending out a pamphlet, or like a piece of paper, that was advocating for men to resist conscription, okay, which is our fancy word for the draft, all right? And they set up this little standard that you see highlighted in your notes. By the way, I would emphasize making sure to write down the yellow highlighted portions and to be familiar with those. The clear and present danger. So saying this is something presents clear or obvious and danger right now present to the public, that speech can be limited. All right. And we will talk about how that ends up holding up over time. But what you need to know is throughout time, this actually gets replaced with this thing that is highlighted right below it, the direct incitement test. Meaning this is that speech that's going to lead to imminent lawlessness is going to become the thing that the court is going to begin to restrict. Okay. And that key word in there is imminent lawlessness, like saying, hey, it's different from saying like abstractly, hey, let's go have a revolution versus let's go and burn down the White House right now. Okay. Direct incitement. All right. So let's keep on moving through. Just real quick on this, this should be pretty obvious. Your free speech rights during wartime are going to be significantly less than your free speech times during peace times. Okay? And as you can see there, as it's underlined, the government advocating for government change in the abstract. Let's go have a revolution. That's going to be okay. But when you say, hey, let's go and overthrow the government right now, let's go down to 1600 Pennsylvania Avenue and set us up a king, that's when we're going to get into some problems, okay? I want to just bring your attention to this Vietnam thing because this is the example we will go to a lot throughout this unit. The burning of draft cards. So when you get drafted, you get a little thing in the mail that tells you when and where you are to report, all right, which military base. And we're going to talk about how symbolic speech plays a role in this. And you will see here that burning of draft cards in protest of the war is going to not be upheld by the Supreme Court. It is going to be something, or punishment for burning draft cards is going to be upheld by the Supreme Court because it is preventing Congress from doing one of their major powers that we see in Article 1, Section 8, the power to raise an army. All right, so let's get into it. All right, symbolic speech. This is nonverbal speech. All right, walking around picketing, heck no, we won't go. All that sort of stuff, wearing armbands, shirts, things like that. You can see down there highlighted, we had a dude who went to a court with a F the draft shirt on, and that ended up being upheld by the Supreme Court and protected because it did not incite a legal action. It was just expressing the opinion, all right? You also see right below it that we've had two cases, both the Texas versus Johnson and U.S. versus Eichmann. That is a state case and a federal case that both concern burning the American flag. And while they were both punished initially, the Supreme Court said, hey, you know what this really is you're asking for reverence to the American flag. That's not really a thing that we can force, okay? That is not something that is outside of your First Amendment rights. Like you have the ability to either show respect or not show respect to the American flag. All right, this is something you need to know. How do I do this? Boom. Time, place, and manner regulations. You need to know this, okay? So limits to freedom of expression based on when, where, and how individuals express their opinions. And this is what you need to make sure you understand, is when they're limiting speech, they are not limiting the content as much as they are the conduct or the medium. Okay, so let's just look at a couple of these real quick. this is a way that the court uses, and this is what you need to know about time, place, and manner regulations. This is what the court uses to deem if free speech is protected or unprotected. So, is the restriction content neutral? Meaning this, you can suppress the medium, but you cannot suppress the content. You cannot say all anti-war speech is unprotected, okay? You can't say like, hey, nobody is allowed to make any anti-war statements. But you can say this, hey, if you want to burn an American flag to protest the war, that's fine. But if you burn your draft card, you are keeping the U.S. government from raising an army. That's not okay. All right? We'll go on to the next one. The restriction has to serve a government interest, like we said, raising an army. It has to be somehow connected to one of the powers ascribed to the government. And it has to be specific. Like I said, you can't just be like, no anti-war stuff. You have to be like, no, you can protest in your particular way, but if you're going to burn a draft card, that is how we conscript. That's how we raise an army. Can't be doing that. All right. And the big thing here is to remember is that you have these alternate ways of expression. And that is one thing courts will express in their opinions. They will say things like, hey, they did this. They could have done this. All right. All right, so this time, place, and manner regulation is going to be important for this next case right down here. All right, this Tinker versus, we're going to call it Tinker versus Des Moines going forward, but the whole name of the case is Tinker versus Des Moines Independent County School District. This is all going to be about speech within schools. All right, so golly, I'm trying to make it relevant to y'all, and you got to know it, so, freaking know it. All right, so Tinker versus Des Moines. Students wore black armbands to school to protest the Vietnam War. They were sent home and told, hey, don't come back until you decide you're not going to wear them anymore. Parents filed lawsuit on their behalf, and in a 7-2 decision, it goes all the way up the courts. The districts upheld the school's decision. The circuit courts, I believe, also upheld. And when it got to the Supreme Court, they were like, hold up now, hold up. You're able to protest, but there's one big thing you got to remember. School is about learning. I know, y'all. Can you believe it? School's about learning. School's about learning, and so as long as you're not disrupting the learning environment, you're good. But as soon as, and this is the actual language they use, the disruption causes material and substantive disruption, all right? So causing a disruption to either what is going on in school or from the material being dispersed, then that speech can be limited, all right? Now, I just believe we've had a couple of students bring up this next case in class before, the Morse Frederick case. A kid goes to like a school function outside of school, and he brings a sign that says bond hits for Jesus. He gets suspended. What you need to know is that the Supreme Court ends up upholding this suspension, and you can think that's smart or dumb or whatever, but guess what? Until you're on the Supreme Court making the decisions, it doesn't really matter what we think. But the suspension is upheld for advocating for drug use, which they say is a substantial disruption to school, because if you come to school high, you're not going to be able to get all the information that you need. Oh my gosh, I know, crazy. All right, let's talk about some speech that has been limited by the Supreme Court. Over and over again, defamation has been limited. There are some exceptions to this once you get into the public sphere with celebrities, but you don't need to know that, and I'm not going to teach it to you, but if you're interested, Google that. All right, defamation is just like, making statements that, hurt someone's reputation. And then also hate speech, okay? So this is specific communication that is either going to belittle a group or characteristics about a group, or just try and make ostracize or make less than, make damaging statements, and it's going to be directly connected to things like race, gender, sexual orientation, all right? I would make sure to know what these are. I'm not saying that you absolutely have to write them fully down, but knowing what these two things are will be fairly important for you. All right. Okay. Obscenity. This is weird stuff right here. Okay. It is offensive or sexual conduct, that lacks literary or artistic merit. And what you need to know is this, is that a lot of obscenity rulings are going to concern things like nudity and pornography early on. And we get a lot of these cases in the 1970s as we're going through the sexual revolution and all of this jazz. And what you need to know is that obscenity laws go way on back, though. Back to the late 1800s, where our early feminists are sending out literature about birth control. And the U.S. government is like, nope, can't do that. God forbid ladies be in charge of their bodies. All right, but what you do need to know is this, is that most obscenity cases that are brought to the Supreme Court, they come from local or state ordinances. Think about our 10th Amendment, okay? Things that are not made by the national government get pushed out to the states. A lot of times the national government is not making rules about certain things, so the states make the rules. Those rules are still subject to the Supreme Court, all right? So, you need to know obscenity along with defamation and hate speech are not protected by the First Amendment. Now, here's the weird thing about it. There's no national standard really to define it at this time. All right, we have a Justice Stewart, who uses this keen phrase. He goes, "I know it when I see it." That does not help us, okay? Because what one thinks is obscene, another person could be like, "Oh no, that's Tuesday." So the main thing I want you to know is that it is not protected by the First Amendment. You can see down there on that bottom line a lot of obscenity convictions in the early time period where we were really looking at these cases get overturned by the Supreme Court. We do get a little bit of help later on in 1973. Miller test. You need to know this, okay? The Miller test, all right? The Miller test is very simply, it's trying to help the courts define what is obscene, so we're not doing the whole "I know it when I see it" thing. Dumb. Okay, Miller test. This is three things. Does it offend an average person in the community? Does it lack artistic, literary, political, or scientific value? And does it depict sexual content as defined by that state? Which means that what one state sees as obscene, another state could say is not obscene, all right? This is why that 10th Amendment really comes in handy here, or is really important to these things, is being able to say, hey, what one state thinks doesn't necessarily mean what the other state thinks, okay? Does it offend the average person? Average person, you get a lot of phrases like that in law that you may be like, what does that mean? And I would say, go to law school. Does it lack artistic, literary, political, and scientific value? And does it depict sexual content as defined by that state? Okay. All right. Some of our basic vocab that we covered are, I just want to make sure that we see this. Please make sure that you know your test. Clear and present danger. You're going to need to know Miller test. I would also know, time, place, and manner regulations. Please know those three. All right, know those three. And also, you need to know this, is that I love you because I love you because I love you. This is hopefully a little bit of a shorter video today. If you do have any questions, feel free to email. You can even put stuff in the comments and I'll try and respond to you. Just know this, I miss you. I really wish that I was getting to see you face to face, but I'm not. I will take a second to tell you that this is a pirate nutcracker. I got this for for Christmas, the year I graduated from high school, when y'all were just little tots. I love it. Okay, but not as much as I love y'all, and I miss y'all. If you need anything, let me know.